I've been talking lately about ways to lower your risk of liability based on your film. Obviously, that's a good thing because it's time consuming and expensive to get sued. But even if you don't get sued, your risk of liability may also affect your likelihood of getting a distribution deal. And also the premiums that you're going to have to pay to get what's called errors and omissions insurance, which is a type of insurance that you're going to have to get to have your film distributed. The type of claim or legal theory I'm going to talk about in this video is called misappropriation of name, voice, or likeness, which is also sometimes called the right of publicity. This involves the use of someone's name, voice, or likeness without their consent for commercial purposes. This is definitely a type of legal claim that you want to protect yourself against as best you can, because the potential damages that are associated with it can be significant. For instance, California's statute about misappropriation of name and likeness provides that the plaintiff, that is the person who filed the lawsuit, can recover any profits obtained through the unauthorized use of a person's name or likeness. If they can't show that the defendant, the filmmaker in your case, made any profits from the unauthorized use of their name and likeness, they can still get $750 per violation of the statute. They can also potentially get punitive damages and recover their attorney's fees, that is, the money they pay their attorneys to prosecute the lawsuit. I'm going to make 6 points to keep in mind about the law of misappropriation to help you to avoid this type of liability. But first, because we lawyers just can't resist disclaiming things, this is not intended to be legal advice, because if I were going to be giving you legal advice, I would need to understand your specific situation and your specific needs. And right now, I'm just a lawyer talking to you on the internet. Second, I'm going to talk primarily about U.S. law. So if you made your film outside the United States or you're getting it distributed outside the United States, different legal rules are going to apply to the protection of people's images, voices, and likenesses. Also, as I'm going to talk about, different laws apply in different U.S. states, which adds yet another interesting layer of complexity. Finally, if you find this video valuable, please hit the like button and subscribe to this channel so I can keep providing more of this educational content to enterprising young filmmakers like yourself. Anyway, without further ado, here are 6 tips that I would give a filmmaker looking to avoid liability for misappropriation of someone's name, voice, or likeness. First, get the written consent of everyone who appears in your film to use their name and likeness. This is true regardless of whether you're doing a narrative or a documentary film. Everyone who shows up on the set of your film should have a contract with a provision that gives you the right to use their name and likeness in your film. You should have crew members sign this as well as talent, or the interviewees if we're talking about a documentary, because they might appear in behind-the-scenes footage or photos, and you might want to be able to use those in bonus DVD features, or you might want to post them on social media, or what have you. Ideally, the clause in the contract that they sign should give you the right to use the person's name and likeness in perpetuity. That means forever, throughout the universe, and in any medium. That is, in the film itself, in the behind-the-scenes footage, in posters or photos relating to the film, on DVD or soundtrack album covers, the whole 9 yards. Here's a good example of this type of contract clause. I've highlighted the most important language here, but as you can see, it gives the production company the right to use the talent's name, image, voice, likeness, or biography for any purpose relating to the film, in perpetuity throughout the universe, and in any and all media. If you're able to get this kind of written consent from someone in your film, that basically eliminates the possibility that they're going to be able to sue you for misappropriating their name and likeness, unless you make a use of their name and likeness that's not permitted by the contract. But of course, there are many situations where it's not possible to get somebody's consent to the use of their name and likeness. And for those situations, there are the 5 points that I'm going to make next. Point number 2, you can be liable for misappropriation if you use a look-alike or a sound-alike actor. In other words, you can be liable for misappropriation even if you don't explicitly use a photo of or mention the name of the plaintiff, that is, the person who is suing you. It can be enough if you use an image or an actor that closely resembles the plaintiff, or the recording of a voice that is similar to that of the plaintiff. The idea is that because you're using an image or voice similar to that of the plaintiff, the audience is either going to believe that the plaintiff is actually in your film, or at the very least, they're going to find your film appealing and want to see your film because of your use of the image and likeness of the plaintiff and their belief that the plaintiff has some kind of association with the film. What are some examples of this type of look-alike or sound-alike misappropriation? In 1988, Bette Midler, the actress, sued Ford, the car company, because they deliberately used a singer who sounded like Bette Midler in a commercial. So again, they didn't show a photo or actually use the voice of Bette Midler, but they traded on the value of her voice because, at least in theory, the audience that was watching the commercial believed it was her, and therefore that she endorsed the product, or at least that Ford had been able to get her to appear in their spot. A court ruled that Midler's claim could go to trial, even though she didn't actually appear in the commercial. There was another case from back in 1983 where somebody decided that it would be a good idea to start a portable toilet company called Here's Johnny, which was a phrase that everybody knew at the time was associated with Johnny Carson, the host of The Tonight Show. Johnny Carson sued them for using his catchphrase, and again, the court ruled that Carson's claim could go to trial. So here, again, the defendant didn't explicitly mention Johnny Carson or use a photo of him, but they used a signature line that had come to be associated with him to sell their product. So this is something to remember in case you decide to use an actor to imitate the image or appearance or the voice of a famous person. Point number 3, you don't have to use the name or likeness of a celebrity to be liable for misappropriation. In other words, generally speaking, a person doesn't have to be a celebrity or to be famous for you to be potentially liable for misappropriating their name and likeness. Even if someone is not a massive star and doesn't have huge social media accounts and so forth, they still have the right to prevent the use of their name and likeness without consent in most states. Now, you might be wondering, if a non-celebrity sues you for misappropriation of their name and likeness, what are the damages? It's not like you can lower the value of their brand because they don't really have a brand. The answer is what I talked about before. Many states' laws provide that if you use someone's name or likeness without consent, they can get what's called statutory damages. That is, even if they can't provide any concrete evidence that they suffered a financial loss because you used their name or likeness, they're guaranteed some sort of minimum amount. The California law on this, like I discussed, says that the plaintiff can get $750 per violation of the statute, regardless of whether they can prove any kind of financial loss or that you profited from using their name or appearance. So this is one reason why you need to make sure, regardless of whether the people in your film are celebrities and regardless of whether they're cast or crew, to get a release from them saying that they consent to your use of their name or likeness. Point number 4, sometimes deceased people's estates or families can sue for misappropriation of their name or likeness. In the last video I did about defamation, which is a legal theory that's different from misappropriation, I mentioned that in general, the estate and the family and associates and so on of a dead person can't sue for defamation on their behalf. They can't sue claiming that you made a false statement about the dead person, in other words. But in the context of misappropriation, some states like California have passed laws saying that a dead person's relatives can sue for misappropriation of that person's name or likeness. As of the date of this video, there are 23 states in the United States that protect the so-called right of publicity of deceased people. These include California and Nevada, for example, whereas on the other hand, New York and Wisconsin don't have these laws. A state statute that protects deceased people's right of publicity usually only applies to people who resided or lived in that state at the time of their death. So, for instance, Ohio's law on this issue would only apply to someone whose residence was in Ohio at the time of their death. There are a couple of exceptions to this rule. The Nevada and Hawaii statutes explicitly say that the person's residence at the time of their death doesn't matter. But generally, if you want to figure out which of these state statutes could potentially apply, you should figure out where the deceased person resided at the time they died. Also, there are differences between the state laws in terms of the amount of time for which they protect the deceased person's right of publicity. So, for example, California's law prevents the misappropriation of the name or likeness of a dead person for up to 70 years after their death. Sometimes it also matters whether the person died before or after the law was passed. So California's law, for example, applies to anyone who died after 1915, even though the law itself was passed in 1984. On the other hand, Illinois' statute only applies to people who died after 1999, which was the year when the law was passed. So there's a complex patchwork of laws that applies to this issue, and it's best to talk to a lawyer if you're concerned about the possibility that you might end up misappropriating a dead person's name or likeness, because believe it or not, that's possible. Point number 5, the First Amendment protects the transformative use of someone's name, voice, or likeness. So in the United States, we have the First Amendment to the U.S. Constitution, which protects the freedom of speech. And the courts have noticed that if the states can pass laws saying that you can't mention someone's name or an image of them without their permission, that can put significant limits on people's freedom of speech. If you're a journalist and you want to publish an article about a scandal involving a celebrity or something like that, it wouldn't be consistent with the idea of freedom of speech if the celebrity could just turn around and demand money from you or could force you not to publish the article because your article mentions their name or uses their photo. So the courts have said that there are basically two situations where the First Amendment protects your right to use somebody's name or likeness. The first is where the person who used the image or likeness is doing so in a so-called transformative way. And second, when the use of the image or likeness is quote unquote newsworthy. Let's start with the concept of a transformative use of a name or likeness. You might have heard that term in the context of copyright law, where it's related to what's called the fair use doctrine. Obviously, it's a long bit of legalese. So what does it mean? One way of thinking about it is that your use of someone's name or likeness is transformative if the use is unique or distinctively yours. For instance, there was a case where a company called Card Tunes, that is C-A-R-D Tunes, made baseball cards with silly caricatures of Major League Baseball players. That use of the players' likenesses was considered quote-unquote transformative because the artist didn't just use photos or create photorealistic paintings or drawings of the players. Instead, what they did was draw silly caricatures, and so the artist's depiction of the players was unique. Another way to think about this concept of transformative use is to say that if the average person would only watch your film because you've accurately depicted the image or likeness of a famous person, the use is probably not transformative. But if the average person would have some reason to watch your film, other than the fact that you did a super accurate portrayal of a celebrity, then the First Amendment probably protects your project. For an example of a literal reproduction of a celebrity likeness that wasn't found to be transformative, in 2001, the California Supreme Court decided a case involving the Three Stooges that found that the defendant's use of the comedy act's image wasn't transformative. In that case, the company that owned the right to the IP associated with the Three Stooges sued an artist who made a lithograph of the faces of the Three Stooges and put it on t-shirts. The California Supreme Court ruled that because the artist just made a literal reproduction of the Three Stooges' faces without any kind of additional commentary or modifications, the First Amendment didn't protect the artist against liability for misappropriation. Another way to think about the Three Stooges case was that the artist didn't do anything that added value to the image of the Three Stooges. Again, he made just a photorealistic lithograph of them with no commentary and no embellishment. The average person who bought one of those t-shirts, in other words, would only do so because it accurately depicted the Three Stooges, not because the artist had done something creative or innovative with that image. But now let's talk about a case that specifically deals with film and TV, which I think suggests that most uses of a celebrity's name and likeness in a film are likely to be considered transformative and so protected by the First Amendment. Recently, the actress Olivia de Havilland filed a lawsuit against FX Networks, which I've talked about before on this channel. De Havilland claimed that Catherine Zeta-Jones' portrayal of her in the TV series Feud, Betty and Joan misappropriated de Havilland's name and likeness. The court said that this use of de Havilland's likeness was transformative, so it was protected by the First Amendment. The court focused on the fact that the average viewer wouldn't watch Feud, Betty and Joan just because of the Olivia de Havilland character. She was actually kind of a minor character in the series, but because of the story of Betty Davis and Joan Crawford and the creativity that the director and writer and crew, actors, and so on put into telling that story. So the bottom line is, as a filmmaker, if you use someone's name or likeness in your film, whether it's a narrative or a documentary film, it's probably only a small part of your movie. So it's likely that that use of the name and likeness is transformative, and so it's protected by the First Amendment. Audience members, after all, are probably going to go see your movie because of your amazing talent and creativity as a filmmaker, not just because you have a name or picture of a celebrity in it. But you should keep in mind that even in situations where the First Amendment allows you to use someone's name or likeness without their consent, without being liable for misappropriation, that doesn't mean that you can use copyrighted material. You can't play a copyrighted clip from another movie in your film unless you either get permission to do that or your use of the clip amounts to what's called fair use for copyright purposes. And whether the use of copyrighted material is considered transformative is only one factor that courts consider in deciding whether the use of copyrighted material is considered fair use. And as you can tell, that's a whole other can of worms that we're not going to get into in this video. But as you can see, that presents its own range of complexities. And my final point is that the First Amendment protects the newsworthy use of someone's name or likeness, like I mentioned. So under the First Amendment, you can't be liable for using someone's name or likeness if you do so for a newsworthy purpose. The use is newsworthy if it deals with matters of public interest, that is, issues that the average person might find important. For example, a while back, you might remember that Michael Moore made a documentary about healthcare called Sicko. Sicko included 3 clips of this guy, Ken Aronson, hanging out with his friend Eric Turnbow in their visit to the United Kingdom. In one of the clips, Turnbow gets hurt trying to walk across Abbey Road on his hands for whatever reason, and afterward Turnbow goes to a hospital in the UK to be treated. Aronson sued Michael Moore's production company, saying that Moore didn't get permission to use Aronson's likeness in the film. The court ruled that the First Amendment protected Michael Moore because he used the clips of Aronson and Turnbow to make his point about the UK healthcare system, which, like the film itself, dealt with matters of public interest, or in other words, it was newsworthy. On the other end of the spectrum, there was a case where Electronic Arts published a video game that used the likenesses of college football players without their consent. So in other words, people playing the game could have these real-life football players on their team. When the players sued EA or Electronic Arts, EA claimed that its use of their names and likenesses was newsworthy because college football is, generally speaking, a subject of public interest. But the court disagreed and said this is not protected by the First Amendment because EA's game wasn't reporting on or providing information about college football. Instead, it was just allowing users to play as real-life football players. So I think the best way to describe the law in this area is that your use of the name or likeness has to support the discussion of the film's newsworthy subject matter for it to be protected by this concept under the First Amendment. In other words, you have to use the name and likeness as part of your discussion of the newsworthy issue. So I hope that was helpful to you in understanding how to protect yourself against liability for misappropriation of name or likeness. If you have any questions you want answered about this, please put them in the comment section below. And thanks for watching.